Next up, we will be hearing more about the expungement piece of this work from Kara Sue Val. She teaches the Youth Opportunity Clinic at Vanderbilt University Law School. She supports teenagers and adults who face criminalization in the juvenile or criminal legal systems and helps them as they navigate kind of collateral consequences of being involved in those systems. But most importantly, for our purposes, she has become a real leading expert in Tennessee's human trafficking expungement law. She does a lot of reentry work generally for the folks that she serves, but this is a real area of expertise for her. And I feel really, really lucky to get to learn from her and partner with her on these cases. So without further ado, Kara Sue Val.
Thank you so much, Savannah. And thank you, Sarah, for that great presentation. I'm really appreciative to Savannah and Judge Escobar for putting this together. I am hoping that you will leave this motivated to do some of this post-conviction expungement work and also really feeling like you have some of the tools to do so. So I'll say this again at the end, and Savannah mentioned it earlier, but if you are interested in actually taking these cases, I am really, really eager to supporting you and making you feel like this is something you can really do with sample motions, brainstorming, working on a guide that hopefully we'll be able to share with you, because these are sort of involved processes, but really, really impactful. And I'm actually in the process of transitioning out of my role and moving back to be near my family away from Tennessee. So I have really loved having my clinic take the lead on some of these early petitions that we filed around the state, but there is a real need for the work to continue. So I'm really committed to making sure that if you want to do this work, you will feel like you have the tools to do that. All right, putting up my PowerPoint here. Okay, great. Okay, so we're going to talk today about supporting survivors of human trafficking in Tennessee through post-conviction expungement relief. You heard about the work that I do now. My background is actually as a public defender, and I really focus mostly on teenagers and young adults and the types of vulnerabilities and collateral consequences that affect them. Of course, many of our clients who we've worked with on this post-conviction expungement relief have been older, but for many of them, they trace back to exploitation or vulnerabilities that stem from that earlier phase in their lives. Okay, so my objectives for today are that you leave really feeling like you understand the human trafficking expungement law, and that you have developed some practical and trauma-informed lawyering strategies to support survivors in post-conviction expungement. And I'm going to just ask a couple of questions and ask people to just drop a 1, a 2, or a 3 in the chat, just so I have a sense of where people are here. What level of experience do you have working with survivors of human trafficking? So drop a 1 if you have lots of experience, 2 if you have some, or 3 if you have no. There's no right answer. Awesome. Give folks another second or two to get that answer in. And I will say, certainly if you have some experience or lots of experience, please do feel free to supplement with your own sort of examples or thoughts either in the chat, or if later on I'll have a few kind of hypos and things, eager to hear from people no matter their level of experience. Great. Okay, I'm going to ask another question now. What level of experience do you have with expungements? The general expungements, not the trafficking expungements. 1, 2, or 3? Gonna write break just to keep track of it for ourselves here. Great. I would say, as we're getting a couple more answers, this is not a general expungement presentation. I will be referencing the general statute some. It is a great and really important and impactful area, I think, for most people to think about adding to their practice. There is expungement of non-convictions. There's the more traditional conviction expungement. Just because we have this tool, the human trafficking expungement law, doesn't mean it's going to be the right way to help every survivor of human trafficking. There are sort of easier and more straightforward forms of expungement that might make sense to pursue, or at least to really make sure that you understand. So I'll be comparing and contrasting the laws so you'll get a sense of it. But I really think it's a great area to add to your practice. And even if you're not specifically working, seeking out these clients in general, the trafficking survivor clients, expungement is a huge benefit to clients in the areas of housing, employment, licensing, such a wide range of areas. So really think it's so important, such important work. And Savannah Quintero and Tommy Robb and the folks at Legal Aid are amazing leaders in that area. All right. Well, thank you everybody for participating in the polling. That's helpful for me to get a sense of the range of experience. All right. The problem. There are really so many problems, but this is how I'm going to talk about the problem that we're talking about today. So there is human trafficking, which leads to criminalization of survivors, which leads to collateral consequences for survivors. I'm going to kind of break down each of these in turn. So human trafficking in Tennessee, we heard a lot about human trafficking in Sarah's wonderful presentation. Working on these cases has been a really eye-opening learning experience for me. I have worked with survivors of trafficking. I think of myself as very trauma aware, thoughtful about a lot of these issues. And there's so much that I did not know and did not understand about working with survivors of human trafficking, and that I'm still in the process of learning. I was frankly shocked at how broad the definition of trafficking is, and how common trafficking is as well. And how much it often does not look like some of those media portrayals, as Sarah flagged. So thinking of it sort of in a general definitional way for now, exploitation of somebody for any number of reasons, using force, fraud, or coercion. Remembering that it, of course, includes exploitation for commercial sex, but also labor and other types of exploitation. I'm not today talking about trafficking of minors. Other than that, it might come up that your clients were first trafficked as minors, and that might be part of their narrative. The expungement process for juvenile delinquency offenses is very different. There's a separate law specifically around prostitution where there's no waiting period, and then juvenile expungement generally is under a completely different statute. So we're just going to be talking today about adult criminal convictions and criminal cases, and how you use a law, this special law, to get rid of those marks on somebody's record. I absolutely had been confused about the moving people around piece. I'm like a little embarrassed about it now, but I'm sharing that just because you should also not feel too embarrassed about maybe having some of these misconceptions. And there's also a lot of different just stereotypes and preconceptions that people bring to the work of working with survivors about where it can happen, often stereotypes about race and what victims look like, the idea of physical violence and physical restraint being part of it, because of course somebody would have run away if they physically could, right? These kind of preconceptions. The idea that as soon as somebody would be able to run away, that they would have or would have appreciated being saved. The first police officer they saw, why didn't they run to them for help, right? Some of those kinds of things. Even if I knew some of these things were false narratives, they're important to kind of think about what are these preconceptions that we or other actors might bring, because you might need to address that in your advocacy and educating other criminal legal system actors through your advocacy as well. And certainly prosecutors understand this actually as well as people with more of a defense background or other types, that trafficking survivors are often not perfect victims, right? Like, just because somebody has a very sympathetic story in one way doesn't mean that across the board it's going to be sort of a single thread. There are all sorts of things, and this comes up in the kind of work we're doing, where somebody very well might have needed to commit crimes to survive, or connected to their trafficking. They might not have they might have issues with their memory, some of the things that we were talking about earlier. So really needing to be thoughtful about those stereotypes and preconceptions to make sure they're not coloring our representation, and to make sure we're prepared to address them if we need to, with judges, with prosecutors, with other actors. Okay, I am going to drop a website in the chat as I show you this next slide here. This is a pretty cool website, Engage Together at Tennessee. And what I have up on the screen here is a list of county level vulnerabilities. So Sarah spoke about exploiting vulnerabilities, and this organization looked county by county in Tennessee. And if you go to that website, you can click on county specific reports, regional reports, state level reports, where they've gone through a bunch of different vulnerability factors to give sort of a score to each county and each region. And it's really just helpful and interesting. I recommend people look up your own county, look up counties you practice in, poke around. It also has a long list of organizations working to support survivors or to address the underlying vulnerabilities within each county. So I just want to flesh out some of those vulnerabilities, what they might look like. There are demographic related vulnerabilities. So things like disability, citizenship status, English language proficiency, can all be factors in affecting how vulnerable a person or a community might be to trafficking. Socioeconomic factors are huge: poverty level, homelessness rates, and things like that. The other one that jumped out to me because of the area that I work on is youth. So statistics related to educational challenges, things like truancy, dropouts, unmet needs, juvenile arrests, and disconnected youth are some of the things that sort of jump out to me. And substance use and dependence, as Sarah flagged, are huge vulnerability factors across demographics and across populations. But this is a pretty cool resource to do a little more research within your own areas of practice, and can be helpful both in understanding the lay of the land in terms of support services, as well as in terms of vulnerabilities. In the county-specific reports, I actually have that link handy too. It's really striking how sort of diverse the counties are that have really high levels of vulnerability. So the counties that are identified as having that highest risk of human trafficking, they really reflect the geographic and socioeconomic diversity within the state. So it includes the state's largest metro areas: Memphis, Nashville, Chattanooga, and Knoxville, rapidly growing regional transportation hubs, tourism destinations, transportation corridors, as well as rural agricultural counties. And it's across all grand divisions in the state. So it's clear that trafficking is something that affects communities regardless of their size, their economic base, their demographic profile. It's not solely an urban issue, and not solely isolated in certain parts of the state. All right, I'm still giving a little bit of background before I pull up the post-conviction expungement statute itself. These are the state-specific definitions related to human trafficking. So This is the statute 3913-309. Sarah said it correctly, about trafficking a person for commercial sex. You don't need to take it in super quickly right now. You can look it up at your leisure. But it builds in this idea of coercion and force, both into the definition of commercial sex. Commercial sex, which is up here, is defined as involving coercion, except for somebody who's under 18, where it's automatic. And then it lists all these ways, these means through which a person might induce somebody else to provide commercial sex. And it's interesting and helpful to see that the law really goes beyond those sort of stereotypes or preconceptions to list a really wide range of ways that somebody might be coercing or controlling another person in terms of providing commercial sex. So it's a non-exhaustive list, so it may include, but it's not limited to. And it includes physical harm or threats, abusing legal process. So just for example, threatening to make a claim to DCS and have your kids taken away, like things like that, abusing legal process, getting somebody arrested, harming a family member through legal process, controlling someone's identity documents, blackmail or financial harm, or this really big one, again, that Sarah highlighted, facilitating or controlling a person's access to a controlled substance. 3913-307 is the similar statute, but focused on involuntary labor, so labor trafficking, same modes of control listed here as well, really similar language. So the law is actually pretty good, I think, at breaking out of some of these more stereotyped ideas of what's involved in force and control. People might not be aware of it, so there's usually like a educating the DA, educating the judge, educating the public dimension to it. But the law is pretty expansive in terms of its definition of who is a victim of trafficking and therefore who's a survivor. You might be able to use this law to support. Okay, so back to our problem slide here. That's human trafficking. I wanted to talk next about these two other concepts, criminalization of survivors and collateral consequences. I talk a lot in my work about the process of criminalization related to young people. So it doesn't just mean like the process of getting somebody like to commit a crime. Like you could commit a crime, you could get a conviction, that could be the end of the story. Criminalization is a social or political process where we as a society mark and treat certain people or groups of people as criminal. So the same conduct that from another population, like for young people, you know, a young person might be out after dark and we might be like, that's cool, they're having fun, right? And then you might see somebody else in a certain neighborhood and think like, oh, that's some sort of violation or that's sort of curfew violation, right? Like what do we mark as criminal and what do we not? Within the context of human trafficking, often what we see in the story we construct around survivors is a story of criminalization, or at least that's what the criminal legal system does and sort of socially that we do, right? You see somebody maybe stealing something or engaging in prostitution or lying to a police officer, right? All these things. And we mark those things as crimes, give people criminal records, and then start treating them like they are criminals. Once we do that, there are all these spillover negative effects, which I and many others sort of talk about as collateral consequences. So those are that they can be understood very broadly. There are just restrictions or limitations on someone's life opportunities because of contact with the criminal legal system. There are certain ways of thinking about them more formally. I'm going to drop a link in the chat just because I think it's fascinating. There is a national inventory of collateral consequences. It only includes formal legal bars because of criminal convictions. You can put in your state, search by areas. There's huge numbers of legal barriers, but it extends beyond legal barriers. Like you can't run for office if you have, you know, this kind of felony conviction or something like that. That's a legal barrier. But also like you might be denied a job. You might not be able to access housing. You might not be able to get that professional license. Those aren't necessarily laws about that, but they're still significant collateral consequences nonetheless. If people have other examples, I don't want to do a super exhaustive listing now, but other examples of collateral consequences that you have seen friends, colleagues, or clients navigate, I'd love you to drop those in the chat, areas where their lives were made harder because of criminal convictions or other contact with the criminal legal system. Having a criminal record and having these collateral consequences not only make it harder for a survivor to just live a free, successful, safe life, it also makes it harder for them to get out of the trafficking situation that they're in. So many people have acknowledged, including the U.S. State Department, other advocacy organizations, that having a criminal record for a survivor makes it harder to get out of a trafficking situation and harder to stay out because it's much harder to build a life that is free and safe. All right, so now I am going to turn to the law we've all been excited to talk about here. This is sort of an obnoxious way to do it, but I can't add a, I don't want to bury, Savannah just put the second word in the chat and I'm about to bury it with the language of the statute. So check that out while I copy and paste this. So this law has changed a lot, mostly in small ways in the last couple of years, but this is the full text. I strongly recommend looking at it within Westlaw, Lexis, wherever you get your most updated information about the status of certain statutes. And that's the case with all expungement law. It tends to change just about every year. So I'm also going to drop a link to this on, I don't know how to say it, justia.com, but it is out of date and it refers to the old sections of the expungement law. It refers to section 101, where now a lot of that content is in 107. So the link is outdated, but maybe easier to look at. And I put the text in the chat as well. Okay, so this law, Tennessee Code Annotated 4032-105, was passed in 2019 and then revised in 2022 with very strong bipartisan support. I think it might have been unanimous. And the goal of this legislation was to give survivors a way out from their trafficking-related records and their convictions. So sponsors spoke pretty expansively about it. Senator Gardenhire said it's a one-chance bill for those battling the horrors of human trafficking to see the light at the end of the tunnel, to clear their records of those charges related to human trafficking, and hopefully obtain gainful employment and rebuild their lives. And it is proven to be really impactful, even as over time we've seen sort of some areas where it definitely needs to be improved. So there's some really strong language about its intent and what it's supposed to do, the strong support for it. And I actually think you can use some of that language around intent and the strong support for it in your advocacy. This wasn't some, fringe thing that got through by the skin of its teeth, making people more comfortable with this. There is very broad political and I think social support for this legislation within the state. So I'm going to turn now to how the law works and talk about a couple of different things. The first is eligibility. Then I will compare and contrast it with the general conviction expungement statute. If you're familiar with conviction expungement, this will probably be very helpful. If you are not, it might be a little confusing, but hopefully it will inspire you to learn also about the general conviction expungement statute. I'll talk through procedure and then go over some petition and affidavit content before turning back to some of those themes around trauma-informed advocacy and sharing a case study as well. Okay, so for eligibility, there is a 4-part test. There's the question of offense eligibility, which offenses are eligible. There's the question of whether there is a nexus to trafficking. There's a question about sentence completion. And then there is a 1-year waiting period. So those are the 4 parts that you need to look at. Okay, so for offense eligibility, there are 2 sections, A and B, that is talking about sort of general requirements. And then with C, it shares some more offense-specific information. And I'm actually going to start with C. So C is saying that the offenses that you can expunge under this statute, they need to be individually eligible for expunction under section 4032-107A1. I'll pull that up for you in a minute, some examples from that. But that is the general expunction statute. So the general expunction statute lists a bunch of offenses and it explains what's eligible under that law. The offense needs to also be eligible under the general expungement law in order for you to use the human trafficking law to expunge it. There's one exception here, which is aggravated prostitution, which is engaging in prostitution with a positive HIV status. But that is eligible as well, even though it's not eligible under the general expungement law. And actually, I'm going to show you the next slide and then kind of go back to this. So for the offense eligibility under 4032-107, there are certain misdemeanors, C, D, and E felonies that are eligible. For the felonies, you want the offense to be included on the list. So if you're looking at a felony and finding out, is it eligible for human trafficking expungement or regular expungement, you want that offense to be included on the list of eligible felonies. For misdemeanors, they did the opposite approach because most misdemeanors are eligible, so they only listed the ones that are ineligible. So for misdemeanors, you do not want your offense included on the list. Okay, so you would look at that other part of the statute, see, is it a listed felony? Is it a not listed misdemeanor? Great, you've passed that first step. Okay, so that's how you show C1, it's individually eligible for expunction. There are two additional requirements that get layered on top of the general eligibility. One is that there can't be an element of the use, attempted use, or threatened use of physical force against the person of another, and it cannot involve the use or possession of a deadly weapon. Very few of the eligible offenses do involve force or do involve a deadly weapon, but a couple of them do. So in addition to looking at the offense itself, you're going to want to look at the elements of the offense and see if it involves a deadly weapon or use of force. I have some sort of thoughts on how to navigate that, but there are a couple, there are some assaults that are eligible, not very many, but some assaults are eligible. But I think it would be a very hard argument. You can still try to look at the underlying facts, see if force is actually involved, it was pled to, but that is likely to be one that will be out under these two additional layered requirements. Okay, so that is offense eligibility. You check the regular statute, you layer these two additional requirements on top. Okay, the next question is the nexus to trafficking, the connection that the offense has to trafficking. This is really interesting, and I think you need to do a bit of a close reading to realize it's a pretty expansive understanding of having that nexus. So there's different language used in two different sections. One says it has to be offenses related to their status as a victim of human trafficking. The other said it resulted from the status as a victim of human trafficking. I don't think that there's much sunlight between those two phrasings, but it's interesting that they are not consistent. And then it references 3913, 314. You'll remember I showed you 309 and 307. 314 just lists all the trafficking offenses, and it lists 309 and it lists 307. So you would go look at the statute, click through to 309, 307, refresh your understanding of what human trafficking is and how broad it can be. And then you would need to think about whether the convictions you're looking at resulted from the petitioner's status. There is some additional information here that I think is helpful. It says that this does not require that there be a conviction for an offense of which the petitioner was a victim. So you don't need the trafficker to have been prosecuted and convicted in order for the person to pursue relief under this. And also it says any offense to be expunged must have occurred on or after the date on which the petitioner became a victim of human trafficking as determined by the court. So it's really important to figure out sort of what is the earliest date. Again, often it'll be the case that someone was trafficked as a youth, as somebody who was under age of 18. That's relatively easy, an easy date to identify because you don't need to identify additional force or coercion. But whatever that initial date is, that's going to be the first date, and the convictions that you're looking at have to be after that. Notably to me, it does not say that the offenses to be expunged must have occurred during the period that the person was a victim of human trafficking, just that it has to happen after that date. So that strongly suggests to me, and I think it's how it's written, that convictions that happen after that period of trafficking, but that still resulted from that experience of trafficking, that those can count as having a nexus to trafficking. It would be very fact specific, but it very explicitly leaves that open. It doesn't say it needs to be during the time period. It says it all needs to be after the date they became a victim. Okay, just checking the chat. Okay, if you have questions wanting to clarify what I'm saying as I'm going along, please feel free to put that in the chat. I'm happy to pause and make sure to clarify. Otherwise, we'll have a chance to talk through any questions at the end as well. Okay, so the next eligibility requirement is sentence completion and the waiting period. So I'm combining two of those steps here. So at the time of the filing of the petition for expunction, at least 1 year must have elapsed since the completion of the sentence imposed for the petitioner's most recent criminal offense. And the petitioner must not have been convicted of any criminal offense during the 1 year prior to filing the petition and must not be subject to any pending charges. So they must have had no cases, their cases must be closed and then no cases in the past year before you are able to file. So that is the waiting period. And again, I'll contrast that with the general expungement statute. And the sentence must be completed. So any term of imprisonment or probation, any outstanding conditions of supervised or unsupervised release, and if required by the conditions of any of the sentences imposed, must remain free from the dependency on or abuse of alcohol or a controlled substance or other prohibited substance for a period of not less than 1 year. I did want to flag that it's a lot of our clients and a lot of people who've been trafficked, substance use is a part of their story, and the exploitation of any substance use disorders is often part of that story as well. But it's not every case that has an order to remain free from dependency or abuse of alcohol. So that requirement is not going to apply to everybody. And you'd have to look back at the records specifically. At the same time, if somebody does have a history of alcohol abuse or controlled substance use or abuse previously, in terms of helping your client figure out when it's a right time to move forward on one of these, making sure that they are in a comfortable place in terms of that, whether that's sobriety or just other healthier habits with support around substances. It's really important to just to recognize the important and complex role that plays in many of our clients' lives. Okay. Oh, one other thing I just wanted to note is that the 1 year period is from the most recent criminal offense. And that's even if the most recent criminal offense has nothing to do with trafficking, right? It could be something that is completely unrelated. You're not even trying to get it expunged. The way that it's written is that you'd still need to wait 1 year from that offense, which is a little counterintuitive. Okay. So I just want to highlight what is not required, and then I'll put it next to the general expungement statute to hopefully drive that home. So it is not required that you only have 1 or 2 convictions or that you're only pointing to 1 or 2 convictions. There is no cap on the number of convictions that can be expunged under this law as long as they are eligible. There is no bar from prior ineligible convictions. The general expungement law, as we'll see in a moment, has very complicated rules about the order in which your convictions happened, and an ineligible one can disqualify you from any expungement. That does not apply here. There is no bar from prior ineligible convictions. So you can exclude a certain conviction, but then expunge around it as best you can. There is also no requirement to pay court fines, fees, or court costs. That is a huge barrier to expungement, and it does not apply when you are using this law. And the nexus is kind of broad, and it does not require that the person committed the crime under duress or at the direction of the trafficker. It doesn't require that somebody would have had a full defense, right, of not wanting to do it, but being forced to do it. And it doesn't require even that high level of connection. All right, here's my little conviction versus trafficking expungement chart. So in terms of waiting period under the general expungement law, most offenses have a 5 or 10-year waiting period. This law has a 1-year waiting period. That's a great benefit to somebody to be able to get expungement to work for them at a point where they're still able to use it to rebuild their lives, as opposed to needing to wait so long and needing to struggle with their record that entire time. Number of convictions. Under conviction expungement, there's a maximum of 2 eligible convictions, so 1 felony and 1 misdemeanor or 2 misdemeanors. Under the human trafficking expungement, it is unlimited. I have one client who I expunged 86 convictions for, and I'm still very grateful to the clerks in TBI for helping me with that process. But it's a completely different level and degree of remedy than the general conviction expungement. For which convictions are actually eligible under the general law, you look at 107 and just see is the offense eligible before you do that dance about how does it fit in with other ineligible offenses. But under our law, it's a little harder. It's 107, that list, plus no force or deadly weapon. Under the regular general law, eligibility is blocked by a prior ineligible conviction, but it is not blocked for the human trafficking law. And for conviction expungement, court debt can block expungement. You have to either repay it or get it waived through indigency. But for human trafficking, it does not block the expungement so long as the sentence is otherwise completed. And once it is expunged, the court debt goes away as well, unless the victim has turned a restitution order into like a civil order or something. But typically, any court debt connected with the offense gets erased as well. So pretty exciting for a lot of our clients, especially those for whom that's holding up their licenses or causing other problems in their lives. Okay. One other thing that I should probably have on this chart, but didn't put, is that within the conviction expungement, if you meet the eligibility requirements, there's a presumption in favor of the petitioner. And in the human trafficking law, there is not a presumption written into the law. It also, as you'll see when I talk about sort of the process, it requires a lot more work. It requires a lot more work both from the lawyer and from the client, the survivor. So it's important to think through whether the benefits of using the human trafficking law are going to outweigh the costs, and whether using the regular conviction expungement, helps most of the way, if not all the way. Like, is it worth doing this much more challenging process? And I'm mostly worried about more challenging from the perspective of the client. Is it worth going through that versus just sticking with the general conviction expungement statute? So definitely important to think that through and to think through pros and cons. Okay, so now I'm going to talk a bit about the process for filing, as well as some of the kind of weird and challenging some are jurisdictional issues and some are just process issues. Okay, so you are supposed to file in the court of last conviction. The statute says that, and it provides for a consolidated petition statewide. So a huge benefit of that is that you do not, as the lawyer or as your client, need to run around to all the counties where you have convictions and go through this process from scratch. Instead, you file it in the court where you were last convicted. Again, it's written a little oddly in that it's not the last conviction you're seeking to have expunged, it's just the last conviction. So it might be a conviction that is unrelated to trafficking, but that could still be where you are required to file. but it streamlines it in terms of there being a single place to process this entire petition. Then the clerk's office in that county of last conviction is to serve, supposed to serve all of the relevant district attorney's offices. So the district attorney's offices where any of these convictions are from. So they send that out, and then the DAs have a 60-day response period in which to submit any objection. If they have it, they should send it both to the petitioner and to the court. I strongly recommend, and I'm going to transition now to thinking about how to use sealing or other modes of protection to protect your client's privacy while this is out there. Of course, ultimately, the goal is that the expungement would be granted and the records would be expunged and not accessible. But while the petition is pending, they are public records. Somebody could request them. They could be lying around the clerk's office or in the judge's chambers. So I strongly recommend using sealing to protect client privacy. Okay. So I have found often you can speak with the DA in the county where you are planning to file, and often DAs are willing to consent to file something under seal, and then certain judges want to still docket the motion in order to rule on it. Some are happy to do it in a more formal way, dropping it by chamber, saying it's on consent, seeing if they, want to docket it or not. But it really depends. I do recommend requesting that clients' presence be excused on all any appearances where their appearance specifically is not necessary. So showing up to request that something be filed under seal, I'll always ask in advance, can my client's presence be waived? And that if you do have an appearance, it's a good opportunity to clarify whether your client's presence can be waived unless there's a specific need for them to be present. And I think that's really helpful. I mentioned I'm happy to share sort of examples of motions and things like that. So if you end up signing up as being interested in taking on these cases, I'm happy to share with you what I have used, agreed orders, contested orders, and motions to file under seal. Occasionally, I have had a DA once object to having something be filed under seal, but I've always had judges be comfortable with it. The one thing that I have encountered is sometimes I have the petition with the client's affidavit sort of as part of the petition, but I've had two judges actually, specifically request that the petition be separate from the affidavit, where the petition was filed not under seal, but the client's affidavit was filed under seal. So it might be helpful to have those as separate documents, or at least to have this appearance about filing under seal, so that then you can know if you're preparing one or two documents. I think it's ideal to have it all under seal, but it's really the client affidavit that has the most information that you really want to be protecting. Okay, so for the actual petition and the affidavit, I'm going to talk a little bit about the content of these. I think I have. Okay, I have slides for petition and for affidavit. One thing I will say generally is that there's often a question of sort of, do you use sort of a form petition or do something a little bit more bespoke? Certain counties actually have prepared petitions specifically for this. I'm going to drop Davidson County has a human trafficking petition. I still think it would be very hard, if not impossible, for someone to do it pro se, just given some of the complexity. But it's a great place to start in terms of what these can look like. The petition content, just like the sample, I like to track the language of the statute, just making sure to list all the statutory requirements and stating that they're met. There are a few things I typically like to sort of elaborate on slightly. If there are any non-convictions that I'm asking be expunged, you want to make sure that it's properly reflecting that. I also find it helpful to specifically list the charges that are not included. So often it'll be, you want to expunge all of the client's convictions, except there's two, one DUI and one assault case, and those two are not eligible. So you list the eligible ones. I often will put that both in the body and in an appendix in the back. But I'll often say something like, they also have conviction this number and conviction that number. They are ineligible because they are not on the list under 107, although they also happen during the time period of trafficking. I think that's helpful, honestly, for the TBI when they're going back through and figuring out, as opposed to just to have a sense of, I meant to expunge everything except for these. It's also a helpful thing for clients to have, sort of affirming this understanding this is during that same time period, because if that stays on their record, they might potentially want to use this expungement order in order to confirm that most of their record is expunged, but also to explain, I do still maybe have 2 charges on my record, but they are from this time period in which I was being trafficked, and look, everything around it was expunged. So I've had that be really helpful for clients, especially those seeking professional licenses. So there might be additional sort of tweaks you want to add. Of course, you need to be transparent about what you are adding. But generally, both my sort of bespoke version as well as that sample track the statutory language. Sec. Okay, for the affidavit content, okay, you want to be thinking through who the audience is for your client. Certainly, the district attorney is part of your audience. Probably the primary audience is the judge who's going to be deciding it. It's not just the DA in your county, it's the DAs in the other counties as well, our audiences, the judge, and then your client as well, right? Your client, I consider part of the audience as well, and wanting to really be thoughtful about how you, what information is in the affidavit from the client, and how will that affect your client as well. Something I really try hard to do, both because I think it's helpful for the DA and the judge and for the client, is to think about a positive framing. Sounds a little weird to think about a positive framing for a story about human trafficking, but often when you're working with a client on this, you're going to find that there's some great information about where they're at now, right? What they've managed to get out of it. They have at least that 1 year clean. I've connected with many of my clients through wonderful programs where clients are working really hard and in an inspiring way to better their lives. Many have gone on to help other survivors. There's often a lot of really good information to include. And I try to include that both sort of up top and sort of at the end, sort of the end, including sort of goals, hopes, dreams, what they hope for themselves. I think it both helps with the affidavit content and helps that reading experience for the client and helps us feel like a positive step forward. Your goal in the client's affidavit is to address the primary statutory question, which is that nexus to human trafficking, as well as to address justice and public safety, because those are the elements that go into the judge's discretion about deciding whether or not to, whether to accept or deny it. And hold on, I'm trying to find my earlier slide. Okay, so this nexus to trafficking section that we looked at earlier, it explains the petitioner may provide evidence of this requirement of that nexus by testimony or affidavit. So there are, I guess, 2 approaches for the audience, for the affidavit. I have approached all the cases that I've handled so far from the perspective of realizing that testifying in this case about their trafficking, about the connection to each of the criminal cases over a large amount of time, when they were in trauma, when they were often using substances, is going to be very hard and re-traumatizing for a client. So my strong preference, my clients' strong preferences have been to submit that nexus information by affidavit. And a lot of the work involved in these cases is working with a client to develop an affidavit that reflects their experience and their voice. So that nexus piece is really important, and then giving enough information that a judge will feel comfortable using their discretion to grant the expungement, finding that it is in the interests of justice and it is not adverse to public safety. A big question that I often struggle with is what level of detail to use in an affidavit. There are pros and cons to using varying levels, and I'll just kind of lay out the challenge. And I think it's a bit case specific. So on one hand, the more detail that you provide, I think it might be the case that the more that might make the affidavit more effective, make testimony less likely to be required. But as Sarah was saying before, memory issues and trauma like cloud a lot of these details. So sometimes adding a lot of details, while it might make testimony less likely, it would make testimony a lot harder likely. Just because keeping dates and times and timelines straight on the stand under pressure is going to be especially hard. Keeping as a, again, completely accurate, but sort of higher level of generality might make it easier for clients to speak about it. Having more detail, if a DA were, I've typically found DAs, they are worried about victims. They're typically on board with supporting our clients through these processes. But if you did have a client who were hostile to your client, giving them a lot of detail in the affidavit is also just giving them more detail that they could use to cross-examine a client, make them look maybe like they're not being accurate or not being truthful just because they're mixing up details. So I think there's some real cost, including very high levels of detail. If you include too little detail, then you might be more likely, a judge or DA might feel like they are more likely to want to hear testimony. I think there's other ways around that. If a DA has questions, you can answer them directly. You could potentially, in the right circumstance, set up a meeting with the DA or your client, or you could have a supplemental affidavit. There are different ways to remedy that, but you do want to have enough information that the DA and the judge feel like they have what they need to make their decision here. What I've typically done within my client is thinking about, we try to get as much detail as possible, but then work with the client to kind of tell a slightly more generalized story. And often we'll think of the convictions and try to group them, right? So if there's a number of substance-related offenses, if there are a number of substance-related offenses, then you would maybe include information about how substances were used in connection with the trafficking. Maybe it was a pre-existing vulnerability that was exploited and then was sort of used against them. Maybe the trafficker developed the dependency. Maybe somebody was forcibly exposed to substances, right? Setting that out, how it played out. And then you can say during the period from X to Y, I was arrested a number of times for drugs related to my trafficking, right? If you give enough information about the context, then probably you can fit a number of those convictions in together. So thinking of sort of patterns and groups of offenses, some offenses will be sort of odd one-off situations, in which case you could address it in some more detail. Because I mentioned sort of that positive framing, I do suggest a structure that's sort of an introducing your client at the top, a few words about them, hopefully words about sort of where they are now. And then I like to use headings to sort of, usually there's sort of early childhood or existing vulnerabilities, something like that, that gets at sort of the vulnerabilities existing beforehand, a section about trafficking and exploitation. And then hopefully you're able to have a section on escaping trafficking and beginning to heal or something like that. And again, thinking of positive framing around it. So that's sort of how I recommend thinking about the affidavit, but the specifics about sort of what you're using and when, what level of detail you're using and when can be really specific to certain cases. Going to flag a couple of practical and procedural challenges. Some have really clear answers, but seem really confusing, but have really clear answers. Some are just generally tough to navigate. So I am often asked by judges and DAs about jurisdiction. I think it's pretty shocking to a lot of people to think like, wait, I'm a general sessions judge. How do I have authority not just to hear this case, but to issue an expungement order that will cover convictions from around the state? That's not typically how we work. General sessions jurisdiction is typically confined to the county. But the answer is that you just look at the statute yourself. Jurisdiction is statutory, and this statute specifically gives the court of last conviction that ability to hear that and to make the decision for the cases around the state. So I often get that question, often requires pulling out the statute, pointing to the language, but has a relatively straightforward answer there. Another issue, some judges are uncomfortable with this petition, in part because you're filing at the court of last conviction, and typically, and Judge Escobar and the Athena court are the exception here, but typically the judge who oversaw the last conviction, they convicted and sentenced a victim of trafficking in their court. They probably didn't even realize that that's what they were doing. So in some ways, this petition that you're filing is pushing back up against narratives that a lot of both DAs and judges maybe have about their work, about what they're doing, about who defendants are. And it can lead to a lot of discomfort. And so sometimes you want to be thoughtful about either telling a story in a way that maybe fits a narrative the judge is more comfortable with, or maybe you want to intentionally challenge that narrative, and use it as an opportunity to, while making sure this doesn't get in the way of your representation, but challenge the idea of judges and DAs having an understanding of who is appearing before them. Filing fees, really interestingly, I think the best argument, and the one that I stick to, is that there's actually no filing fee in these cases. The statute, the last subsection of the statute does say, upon filing the petition, the petitioner shall pay the clerk a court of fee as described in 4032-101 G9. But that section, G9, was repealed and does not exist. So I think there is no filing fee. I can imagine there might be a situation where you want to push and to fight that, but there might be a situation where someone, might want to fall back and consider paying a single $100 filing fee. That doesn't offend me terribly as long as that's not a barrier. What does offend me terribly is some clerks have said, oh, okay, you're expunging, 86 convictions, so we need $8,600 to expunge that. That is not how the law works. It's a single petition that I think has no filing fee. But even if you think it has a filing fee, it's a single petition. So I think it's really important to push back on that. And then the last thing that's been an obstacle is a requirement for TBI certification of offenses. So for any conviction expungement, there is a relatively recent requirement that there be a TBI certification that the clerk's office gets, where the TBI states whether the offense is eligible or not. It's not supposed to be looking into it's really supposed to be sort of looking at the offense, looking at the lists. Is it on the list? Is it not on the list? Those kinds of determinations, not determinations like, is there a nexus to trafficking? Because they wouldn't know that. The tricky thing about it is that you're asking the clerks in that court of last conviction where you have filed it to get the TBI certifications from around the state. And they will not be able to see publicly, from the public information that they have, they will not be able to see all of the information that they can see about their own county. So I have worked with clerk's offices before to try to navigate that. The TBI has tried to be pretty flexible about this. I think ultimately it's going to require some sort of fix, but what's worked for me is that the TBI has been cool, at least so far, about submitting the certification requests without full information. And that's when information like, we're trying to expunge everything except for these 2 offenses or except for these 3 offenses, that can be really helpful to moving this along, because you can clarify, we are requesting certificates on everything you can see. except for those 2 or 3 things. But sometimes that requires some mediating and follow-up conversations with the clerk's office and with the TBI. Okay. Oh, so that is the clerk's responsibility, the clerk in that court of last conviction, both to get the TBI certifications and to serve the DAs, but often they don't know how to do it. They might need you to explain it, to show them the statute. I'll have a meeting with them and a supervisor just to talk it through. And I also very strongly recommend requesting copies of any proof of service from sending it out, because sometimes judges will ask, when was it served and how do I know it's been 60 days? So you want to have some sort of proof about when it was sent out. All right. I'm going to turn now to trauma-informed lawyering, and then to have one of my wonderful students share a bit of a case study. But I want to pause for a sec and see if there are any questions so far. Okay, great. So Tommy asked about saying more about requesting that it be filed under sealing. Does it delay the expungement process? And when does the 60-day period for the DA's objection start running? Yes, so it does delay it. That's why I would like it to be automatic moving forward. Once you have the order to file under seal, that's when I will file the petition and the affidavit. And only once it is filed, then it gets sent out, and the 60-day period runs from when it is sent out or received. I think it's received by the DA's office, because they have 60 days to respond. So it does delay it. I think it's important to do, but it does slow the process down. Okay. Great. We'll have a chance to ask some more questions later. I just wanted to touch base before we moved over. Great. Sorry, just making sure we're ready for the case study. Okay. So trauma-informed lawyering, you heard a little bit about this from Sarah. Lots of definitions of it. The biggest things are honestly just to be aware of what trauma is, how it might show up for clients, and then a commitment to being adaptable in light of trauma and trauma responses. So promoting client safety and control, and really keeping in mind a goal of minimizing re-traumatization. So a lot of people who are survivors of human trafficking, going to court is not a happy experience for them. For a lot of people, it's not a happy experience. And they likely have had negative experiences with interacting with DAs, interacting with judges, even just walking through the metal detectors, right? All of that can be re-traumatizing. So limiting the number of situations in which a client needs to appear in court, trying to avoid having them testify, trying to be really thoughtful while you're even in your office interviewing and speaking with them. And we'll hear more about that as well. And I'll flag secondary trauma at the end as well. So what is trauma? Trauma is exposure to a distressing event that overwhelms a person's ability to cope. So it's both that experience and the effect on a person's ability to cope and their emotional regulation. A trauma response is a response by a person who has experienced trauma, and is typically talked about as being fight, flight, or freeze, or sometimes fight, flight, freeze, or fawn. And this shows up in a lot of different ways. It can look differently for different people. A lot of the trauma responses are kind of things listed here as protective actions. So being really hyper vigilant, sometimes dissociating, like disconnecting from what's going on, sometimes aggressive responses, or people pleasing. So a lot of these, as you see, fight could be avoidance as well. Or sorry, fight could be getting aggressive or arguing a lot. Flight could be avoidance or needing to leave the room or getting out of a situation or avoiding it. Freezing could be sort of shutting down. dissociating, and fawning is sort of that people pleasing, sort of saying what somebody thinks, what they think somebody wants to hear. And that can be a really big obstacle as well. I am curious if people have seen other trauma responses they want to share in the chat. I'm sure there are plenty of examples from your own practice. So feel free to drop that if you do. Trauma-informed lawyering, great, not leaving the home. Yeah, that's sort of a type of avoidance, is safety, like seeking safety, right, in response to trauma. Thanks, Dale. Awareness, being aware of trauma, being adaptable, those are the main things that we are looking for. Okay, I am honored now to introduce one of my wonderful students. The work that I've done in my clinic is thanks to the amazing thoughtfulness, dedication, creativity, and hard work of my students. And I am going to hand the mic over to my student AJ Johnson, who worked on one of these cases with me this past semester, and is going to share a trauma-informed representation case study with us. Thanks, AJ.
Yeah, thank you, Kara. As mentioned, my name is AJ. I was one of the students in the Youth Opportunity Clinic out of Vanderbilt this past semester, and I had the opportunity of working with a trafficking survivor on this exact expungement statute. This survivor's name, for the purpose of this case study, is going to be Skylar. Skylar had experienced over or just around 15 years of trafficking, which was more than half of her life at that point. And of course, had developed a very long criminal record that we were going to be working to expunge. As Kara has been going through, we had to work on an affidavit to kind of to be filed in court in place of her testimony. And so part of our work was going to be interviewing Skylar and getting the entire story of her history of trafficking and then compiling it into a statement that we would then send to the court under seal. Of course, we were new student attorneys, my partner and I, Carol, and had never done anything like that before. We had read an article about trauma-informed lawyering, but I've learned quite a few lessons over the last semester working with Skylar through this that I was asked to share with the little case study for you guys. So it can kind of be broken into 5 categories. The first was professionalism. One of the big things with Skylar was that, you know, we wanted to explain everything that we would be requiring for the affidavit. And so one of those was explaining what the nexus of human trafficking was and why we needed details, certain hard details of her story to file a successful affidavit. And we would explain kind of what we needed, how much we needed, and what we didn't need, so that we weren't ever hashing details from her that were just going to be painful but didn't have any use. We were also practicing informed autonomy, where we explained to the client exactly what we wanted and what we needed for our processes. And of course, if she decided that she wasn't able to provide those details or those details were too harmful, we were not going to be pushing her further because we'd explained exactly what the details purpose would serve, and she was able to make that choice as the client. We didn't really run into any issues with Skylar not explaining any details to us or not going into her story or being nervous to share that. And I think that was in a large part because at the start of the meeting, we had informed her how the process was going to work, the seal, what we needed in the affidavit, and she felt very comfortable giving us the details that would then be filed later. So that worked really well for us on the professionalism aspect. Another thing was maintaining communication. I will say at the start of this journey with Skylar, I was the one who was communicating with her first. And one of the things that was very frustrating was sometimes it was hard to get in contact with her. Of course, we know with trauma, there is the avoidance occasionally, but what we were running into was we'd heard she's very excited to participate in this project. However, every time that we sent an email, we wouldn't hear back for a period of weeks if we heard back at all. So one of the things that we kept doing was trying to find a different way to communicate. We were trying to find any way of communication that would work best for her and take away some of that administrative burden that emailing perhaps was taking up in her brain. So we tried calling, we tried emailing. What ended up working was texting. And once we got that down, we began to text her regularly about updates on her case when we needed to meet her. Of course, that doesn't always work. There was another partnership in our clinic who had a client that they just never could get in contact with despite trying numerous different ways. And I think something to keep in mind is that if someone has reached out for help under the specific statute, they absolutely need it. But sometimes there's just a little bit of a mental block that is preventing them from doing so, and to instead maybe follow up with them a little bit later when some time has passed, if possible. The other aspect that I learned was to remain human, which kind of, I guess, is maybe in conflict with the professionalism aspect here. But I think being human, especially when someone is sharing a very traumatic story with you, is very important to also develop a relationship with your client. Our client, Skylar, was walking through this experience where her trafficker had manipulated her basically back into trafficking after she had gotten out. And she was very upset during this story. Of course, she was. But one of the big things that she told us was, and it's all my fault at the end of that. And I think that was something that was very heartbreaking for Carol and I when we were hearing that part of her story. Because to us, of course, it was not all of her fault. Well, none of it was her fault. She was being trafficked. She was a victim of a terrible and violent series of crimes. And so it was kind of a knee-jerk reaction, but I told her something along the lines of, it's not your fault for being trafficked. That response is not very noteworthy, but I think it did help her take a breath and circle back to what we'd been talking about before. Of course, if you do have a client who is potentially just circling back to that negative thought pattern and comfort isn't working, it may be best to reschedule it for a different time. But for Skylar, it worked really well, and I think it helped her see that we were looking at her as a survivor as opposed to someone who had fallen for manipulative tricks by her trafficker. The other thing that we worked on was forming a comfortable space for her to share with us during this interview. We made sure that when we were going over her record and we noticed that she had some convictions that were ineligible for the human trafficking expungement, we went over those with her. And we were very clear that while this is on her record, we didn't judge her for those convictions. And we also still had the opinion that those convictions were due to her being a survivor of trafficking and still not a reflection of her as a person. And I think that because we had taken that opportunity to reaffirm our belief in her and our belief in her story, that just helped her feel more comfortable continuing to share with us. The third category of the lessons that I learned was earning trust and creating a safe and secure environment for her to be able to share with us in this interview. We had booked an interview during our spring break here at the law school, and that was done very intentionally. We had figured that most people would not be in the law school, so she wouldn't have to look and see a lot of students passing by the office as we interviewed her. We booked a private office where we could shut the door. And we also went out of our way to go purchase some pastry, some coffee for her to choose from when she got into the office, just to kind of cultivate a safer and more comfortable space for her. If you're doing this work often, one of our biggest gripes is that we had fluorescent lighting, we just had office furniture, and it wasn't very comfortable, even though we had done what we could in the space that we had and with the resources that we had. If you're doing it regularly, consider maybe having like a more homey atmosphere, comfier seating, stuff like that, to really emphasize this safe space for your client. We also made sure to have really great communication with Skylar. Again, I was the one who was handling that with our text messaging. I'd always make sure to start off with, "Hey, how you doing?" And mention kind of, wow, this weekend has been so hot, and just before we got into the details of what we had been discussing, and just really staying on top of that, making sure that she felt that our relationship between lawyer and client was not just about the terrible things that had happened to her, but also it was developing, from human interaction as well. So we also, when we were going over her statement for the affidavit, we were aware that she would be having to read this statement and all of these terrible things that she had told us in the interview. And what we had done is exactly what Kara suggested, where we start off with some of the great things that she's accomplished since leaving trafficking. We go into the details and the nexuses of the convictions that she had, and then we end on some of the amazing things that she's accomplished since trafficking, just to really nail this idea that she is progressing and to remind her that despite the bad parts of her story, she's still moving forward. So that was very important to us with communication as well, is to just reaffirm her trajectory and try to give her hope in some of the ways that we are working towards this. The other thing was understanding the psychology behind trauma. Kara got into a little bit of it. Neither of us are psychologists. I think a lot of it is just kind of, reading some articles, reading the trauma-informed lawyering article that we had been assigned at the beginning of the clinic. And, understanding that when Skylar is telling us, I actually don't really remember what happened then. That's a sign of trauma. Some of the things that we noticed with Skylar specifically was she tended to get confused with the timelines. Either events would be remembered to her as closer together, or sometimes more time would pass between the events than had actually passed. She also sometimes had more emotional responses to particular memories and less responses to others, even though all of them were traumatic. So just kind of keeping an understanding of that helped us move through the process. It's also good to remember that mental illness and substance abuse can be aggravated by trauma. You may have a client that relapses while you're working through this process, or a client who cancels last minute because they are afraid of leaving the house. Situations like that are definitely possible and can happen and are probably likely if you're doing this type of expungement regularly. The last thing that I want to say is that trauma is often cyclical. It's important not to judge your client, and also very important not to make your client feel judged about returning back to trafficking if that's part of their story. As mentioned before, Skylar had been manipulated back into trafficking after originally escaping by her trafficker, but this has happened multiple times. And one of the things that you'll realize with human trafficking and other violent crimes, they often lead a victim to returning back to that cycle or experiencing very similar types of trauma due to lack of resources after the original trauma. And there's also processes of re-traumatization caused by different systems, such as the education system, the criminal justice system, even investigations of the original traumatic event can be re-traumatizing to a victim. So oftentimes you'll see someone come to you and have gone through this cycle many times. But it's important to understand that someone's not returning to that cycle willingly. A lot of times they're being coerced. A lot of times they feel they have nowhere else to go. In Skylar's position, we had learned that drugs were being used to coerce her back into the cycle on a few occasions. One time, her traffickers even used a family member to bring her back into trafficking. And so when your client says something like, I fell for it again, I went back, it's important to know that that is not the truth and that your client is experiencing something that's pretty normal and common with trauma. Anyways, Skylar is now doing great. We did get that filed, and she is excited to get this all expunged.
Great. Thank you, AJ, so much for sharing about your experience. And I think we're trying to inspire lawyers to take on these cases now. And the fact that my students were able to do such outstanding work during the course of their semester hopefully is inspiring some of you that this is something that you can take on yourself. I'm just going to wrap up my presentation now before turning it back to you, Savannah. Okay, so I wanted to share one more concept around trauma. I think a lot of us have heard this term. Hopefully it is something you're thoughtful about in your own practice, no matter what type of law you practice, and that's secondary trauma. So secondary trauma is emotional distress from hearing secondhand about traumatic events. It's really common in helping professions, including among lawyers. It can feel uncomfortable to take it seriously, especially when you are talking with a client like Skylar, who is so deep in it and has experienced these situations herself, right? You're just in your safety of your office hearing about it. It feels like it pales in comparison. And of course it does, but it doesn't make it any less real. So hearing about and helping somebody process traumatic events leads to trauma. The way in your brain, it activates parts of your brain that make you feel unsafe. Secondarily, not directly, but it can have really negative effects as well. So it's really important that we just be aware that that is something that's going on. So just like often for clients going through these expungement processes, we recommend that they have a support network, that they be seeing a therapist, maybe that they have a caseworker. It could be a great chance to reach out to Hope for Justice or another one of the wonderful nonprofits supporting survivors of trafficking, just as they should have supports. You as a lawyer should think about, what is your support network? How do you talk through and process some of this really challenging work? Because without saying that this is in any way minimizing our clients' trauma, which of course is much more significant, we often experience trauma even just hearing about it and processing through some of these things. So having awareness about it, thinking about self-care, and thinking about support are really important. So wrapping up, hopefully you are leaving with a sense that expungement in general, and specifically under this human trafficking law, can be very impactful for survivors. I think a great goal for anybody is to think about holistic support. So identifying other resources, maybe even other remedies. Just to flag one, there's a law called the Debt Bondage Repair Act, where if you have a court order saying that you've been trafficking, you can actually use that, submit it to get negative marks on your credit score taken off your record if they are also tied into trafficking. So thinking about sort of ways to support clients in other ways, thinking about client-centered and trauma-sensitive representation, which is essential. I briefly want to flag room for improvement in the law and an awareness. Awareness about this law among judges, among prosecutors, among potential clients, among lawyers, absolutely. Just flagging some areas for improvement. I think having the sealing automatic would get at what Tommy had flagged in terms of it currently delaying the process. These things should be under seal automatically. As AJ was saying, sometimes victimization through trafficking is cyclical. Right now, the law is a single-use statute and seems to have this idea that, if you got out of trafficking but then get sucked back into it, that's your fault and you're no longer worthy of this expungement. And that doesn't reflect the reality of a lot of people who are trafficked, especially when there are vulnerabilities that continue to play out in people's lives. As far as resources, I'm including here my Vanderbilt email, which will work for I don't know how much longer, as well as my personal email. I think on the next slide, I include my Google Voice number. Really do feel free to reach out. I know Savannah Quintero, again, so grateful to you and the amazing lawyers at Legal Aid for taking on leadership around these cases, I think, moving forward. So I think Legal Aid will be a great resource for things like guides, sample documents, and other support. If you do take on this work, it will be really helpful to be in conversation with Savannah and with legal aid. I think the more we track these cases, track information about these cases, figure out which counties have worked through these, this process will get easier and easier for lawyers moving forward. So just really grateful to Savannah again for putting this CLE together, and to all of you for attending.
Thanks, everybody. We've kept you long enough. Just want to remind you to look out for an email to certify your attendance. There are 3 words in the chat that you might want to snag before you leave, and we'll see you next time.